Excellent. Well, we've covered pretty much everything there is to cover about native advertising with just those two countries. And the law that we're going to see in the United States is very similar. But why should I speak when you could just listen to an engaging piece of video? Oh, we don't have audio?
For our ancestors, ads couldn't be avoided, but everyone knew what was an ad and what wasn't. After many years, mankind invented cable, a way to pay for television so there could be no ads. But somehow, the ads still found a way. And so mankind invented TV, a way to skip past commercials. Finally, it appeared to be the end of ads. And everywhere, people rejoiced. The ads were stopped, or so it seemed. With the rise of the internet, suddenly the ads had an entirely new way to attack us. Pop-ups. The top scientific minds were brought together to find a way to stop the ads once and for all. They invented the ad blocker. Suddenly there were no ads on phones, on computers, and everywhere. People rejoiced. But the ads adapted. They became smarter. They disguised themselves as news. All around the world, people read news stories, completely unaware they were reading ads. And now, the ads have taken the next step in their evolution. They have taken human form. Ads are among us. They could be your friend, your gardener. The ads are trying to wipe us out. The question is, how?
So native advertising is basically everywhere, and we're never going to stop it, and certainly not in the U.S. I mean, what's interesting about this video, and I have another video in my presentation, is that native advertising has become such a problem that shows like South Park and Daily Show and others are actually talking about this topic that we here at this legal conference are talking about. So it's pretty unusual. And in the U.S., as in most countries, right, we have the basics of advertising law, Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices in or affecting interstate commerce. And native advertising is really grounded in deception or an omission of a material fact, right? So if consumers don't know that they're being advertised to, that's deceptive. It's an omission of a material fact. That applies to native advertising. It also applies to endorsements and testimonials when there's a material connection between the person, like the Kim Kardashian example, and the advertiser. It's all about disclosure, and it's all about transparency. And it's nothing new, actually. We're looking at this in the United States and elsewhere in the world as, wow, native advertising, this is a brand new thing. Well, it's brand new only insofar as advertisers now have a much bigger platform to use it within. But go back as far as 1968, and there were newspaper columns, and they had reviews of restaurants, and they talked about the restaurant and some of the meals and how good they were. And the FTC took action against that, and here was part of their opinion, this advisory opinion. The sponsored column uses the format and has the general appearance of a news feature. Since the column, in fact, consists of a series of commercial messages which are paid for by the advertisers, it will be necessary to clearly and conspicuously disclose it as an advertisement. So what happened as a result of that? We see this all the time in your general publications, newspapers, magazines. As a result of this opinion, you have that says advertisement on the top of the article or advertising supplement or something like that. Not something that most of us would consider to be particularly clear and conspicuous, which is the standard under the FTC Act in the United States. Here's another example. This was from the 90s, Georgetown Publishing. And I actually received one of these in the mail. It's pretty fascinating, back in the 90s. And it was a book review. It looked to have been torn out of a magazine, and somebody put a postie on it with this note, "Try this, it works, Jay." You open this letter and you read the postie note and you're like, oh yeah, my friend John probably sent this to me, right? Well, this happened to be an advertisement for the book that was part of the review. And what a clever advertisement, but this is, a form of native advertising. The consumer who opened this up, in this case me, didn't understand that this was actually advertising. FTC took action against Georgetown Publishing again in this case. And again, here in the fix here was to put advertisement on the top of the torn out magazine page. I don't think, again, that was necessarily effective, but it's what we've been dealing with. So in the United States, we don't only have the FTC, have the potential for state attorney general actions. We haven't seen any of that yet in native advertising. We have the National Advertising Division of the Council of Better Business Bureaus, our self-regulatory organization. They've been doing some enforcement in this realm as well. This is an action against eSalon and Mashable for failing to disclose it. So in this case, the NAD said the eSalon didn't clearly identify that the blog was sponsored or that it promoted eSalon products, and frequently reblogged and tweeted those sponsored content without disclosures in each post or tweet. So again, the buzzword here is transparency and disclosure, clear and conspicuous disclosure. If you're going to have any type of native advertising, any type of endorsements or testimonials where the endorsers have been paid or have other connection, you have to disclose that in some way. So big news, December of 2015, FTC comes out with this enforcement policy and business guidance with respect to native advertisement. And we see it again, same exact theme as we always have, where consumers may be misled about the source of an ad, and if such misconception is likely to affect the consumer's choices or conduct with respect to the advertised products or services, clear, proximate, and prominent disclosures are needed. So again, this includes whether or not what you're reading is actually an ad, whether or not the person talking about the product is associated with your company or your product in some way. Advertisers are responsible for ensuring that native ads are identifiable as advertising before consumers arrive at the end advertising page. This is the basic policy in the US here. And just recently, the FTC just announced it's the first native advertising enforcement action after the release of those guides in 2015. This was against Lord & Taylor. And what's surprising about this, and they arrived at a consent order, no money was paid, but what's surprising about this is we're talking about Lord & Taylor, huge, very prominent retailer in the United States. And this involved not only native advertising, but the use of paid endorsers, social media influencers. They failed to make disclosures with the social media influencers, and they failed to make disclosures in the native advertising as well. And this was, pretty egregious. And you would think that a retailer like Lord & Taylor would have policies and procedures in place to prevent something like this from happening. And as part of the injunctive relief under that consent order, Lord & Taylor is required to ensure that its contracts have provisions in them with their influencers to make sure that they're making the disclosures. There's also a provision that basically says that Lord & Taylor has to monitor what the influencers are doing. And so while this is an action that's cited and everybody went wild about the fact that it was native advertising, it really was grounded on, again, failure to disclose, endorsements and testimonials issues as well. But and I think we'll likely see other enforcement actions by the FTC as time goes on. This is typical in the U.S. in terms of the FTC's view on things. They'll release a policy statement and then they'll enforce it. So if you have any clients in the U.S., look out for these things.
Really impressed old media such as Time Inc., whose CEO recently created a native advertising team. And he also doesn't see why that might be an issue.
As long as it's clearly marked, as long as the consumer knows the difference between what's editorial and what's native, I don't see any problem with it at all.
Yeah, but it is a problem, though, because the consumer cannot tell the difference. A recent study showed that less than half of visitors to a news site could distinguish native advertising from actual news. And of course they can't, because it's supposed to blend in. You're like a camouflage manufacturer saying only an idiot could not tell the difference between that man and foliage. I mean, look, the camouflage clearly states not foliage on the collar. It's clear. And besides, I'm sure that Dia knows the difference between the two things. Dias are so smart. You have to respect Dia.
I guess we all are just dear to a certain degree, aren't we? So what do you do? How do you make those disclosures? Well, again, the FTC says it has to be clear and conspicuous. It has to be clear, use clear, unambiguous language as close as possible to the native ads to which they relate, in a font and color that's easy to read, in a shade that stands out against the background, on screen long enough to be noticed, read, and understood, audio disclosure read at a cadence that's easy for consumers to follow and in words consumers will understand. And we've all seen some of this native advertising, and a lot of it was not as clear and conspicuous as probably the FTC would like. So I think that's a little bit of what's going on with Lord & Taylor as well, as the FTC is basically saying, look, this is important, we're paying attention to this, and all the advertisers and the publishers as well have to pay attention to these things. And so I think what we're we should be seeing, and I think what we are seeing in the US is a trend towards clearer and more conspicuous disclosures with respect to native advertising. So what disclosures can you make? Well, terms like ad, advertisement, paid advertisement, sponsored advertising content, some variations of that are probably going to be okay. What's not going to work is what a lot of advertisers had been using, things like promoted or promoted stories or you might like or from around the web. Clearly those aren't terms that are getting to the consumer that information that they need to understand that this is actually an ad. And going back to the John Oliver bit, it's for many years the publishers were getting money and paid to have this content on their sites, and consumers were clicking on that content not understanding that these were ads. And I think that's really what the FTC is trying to avoid. Consumers reasonably may interpret other terms such as presented by, brought to you by, or sponsored by to mean the sponsoring advertiser funded or underwrote but did not create or influence the content. And this is where we have a little bit of a distinction, right? This is, you want to use these kind of euphemisms because they sound a little bit better than ad or advertisement or paid content, right? But they don't mean the same thing. And that's why the FTC is going to say these are not going to be sufficient. They may be sufficient in situations where that is indeed the case, right? If the advertiser merely paid or is presenting for the content but had no hand in the development of that content, that's going to be okay. In the recent native advertising guidelines that the FTC published, they gave an example of a running shoe manufacturer basically paying for some content that was about best places to go vacation, but the content had no mention of the running shoes, and it said presented by whatever, Nike or something like that. The FTC said you don't need to disclose that as an ad because it's not in fact an ad. So that's really where you're going to get the distinction. Lastly, where do you place those disclosures? Where consumers will notice them, easily identify the content to which they apply. Place them in front of or above the headline. They should remain when native ads are republished by others. This is an important point, right? So if you see a native ad and you're forwarding it to your friends, or you have the ability to share that content with other people, that disclosure might get lost. And the FTC said that's really important. The disclosure has to stay with that, because just the mere fact that I may have shared a piece of content with my friends doesn't change the fact that it's a native ad. Visual cues should make it clear if disclosures apply to more than one native ad in a grouping, right? A lot of the times you have on a website, you have a group of content on the bottom, and it's all native advertising. Is it clear that all of that advertising is advertising and not content? And finally, for multimedia ads, disclosure should be delivered prior to consumers viewing the content. And you think about what might happen here in a case like this, right? If I'm tweeting out something, but there's a video attached to it or a video linked to it, I may not know, or the consumer may never view that video. And or if I look at that video, I may not, I might click on that video, think it's content and not advertising. The consumer has a right to know that that video is actually advertising and not content, what the FTC would call deceptive door openers. And that's it from the US. So I'll leave it there and turn it over to India.
So